Good morning. My name is Michael Keyes. I'm a senior diplomatic fellow here at the Wilson Center, standing in today for Robin Quinville, the director of the Center's Global Europe program. It's a pleasure for us at the Woodrow Wilson Center to host this panel discussion on the very timely topic, From Freezing to Seizing, the Future of Sanctions. As noted in the event description, Russia's illegal aggression against Ukraine has led to a new level of comprehensive sanctions and intense coordination between the US and Europe. There is an ongoing debate on both sides of the Atlantic on ways to use sanctioned assets to compensate for the damages incurred by Russian aggression and to support Ukraine in rebuilding the country. Today's event will discuss the step from freezing sanctioned assets to their confiscation and repurposing from a legal and political perspective. This topic is of particular interest to me, since I'm working here on detail from the State Department on a paper which looks at how to engage Russia in a post-Russia-Ukraine conflict situation, dealing with the remnants of the conflict features in my paper. So I'm going to be learning from this as well. On that, I do need to note at the start of this that I am an active State Department Foreign Service officer, but that what I say or ask today may not necessarily reflect the views of the State Department or the broader US government. So I'd like to thank our hosts, the Wilson Center's Global Europe program, which addresses vital issues affecting the European continent, US-European relations, and Europe's ties with the rest of the world. The WABA Institute for Strategic Competition, which works to help America and its allies to deter aggression and secure a global rules-based order, and the Kennan Institute, to which I am detailed, the premier US Center for Advanced Research on Russia and Eurasia, and the oldest and largest regional program at the Woodrow Wilson International Center for Scholars. For those of us who may not know here or in the online audience, the Woodrow Wilson Center was established by an act of Congress in 1968 as a nonpartisan living monument to our 28th president and a bridge between scholarship and policymakers. We place value on history and regional context and fold them into our products. Presentations and panel discussions such as the ones that we will enjoy today are exactly for what the Wilson Center was designed. Today's hybrid event is being attended in person and online and is being recorded. As your moderator, I will do my best to take questions from the audience physically present for answering when that time comes, and we'll certainly have one or two questions of my own. But we're here this morning to hear from our guests, and so without further ado, it is my honor to introduce His Excellency Ambassador George Sparber from the Principality of Liechtenstein, who will introduce our keynote speaker. Ambassador Sparber has been Liechtenstein's ambassador to the US since September 2021, and his embassy's collaboration with our Global Europe program has been a wonderful partnership under his leadership. Your Excellency, the podium is yours.
Thank you again for your kind introduction, and to the Wilson Center for hosting us today on this very timely topic. And we're glad to continue our really excellent relationship with the Wilson Center to contribute critical expertise to current policy discussion. The brutal aggression war of Russia against Ukraine has brought the transatlantic relationship to a new level. Cooperation on sanctions has been very close between Europe and the US, and there is a very strong ongoing commitment to fight authoritarianism and kleptocracy together. Of course, that also means that we're asking ourselves the same questions now on both sides of the Atlantic, what the future of those sanctions will be, how we can best support Ukraine in what will be a massive rebuilding effort, and that will cost a lot of money, how we can use some of the frozen assets to that end, and really a lot of related questions to that as well. We, as Liechtenstein, follow these discussions very closely, in particular in the context of the European Union, and I hope, and I'm sure actually, that we can make a contribution today with this discussion to an ongoing exchange between Europe and the US that we believe will be very instrumental in advancing those questions. With that, it is really a great honor for me to welcome our Minister of Infrastructure and Justice, Her Excellency Graziella Marok-Wachter, here in DC for this discussion. Minister Marok Wachter has a doctorate in law and a long experience in the private sector, in particular in the financial sector. She has headed our administration's office for justice, that is responsible, among many other things, also for international cooperation in judicial matters. And since March 2021, she's a member of the Liechtenstein government. And of course, Minister Wachter, as you will have heard, brings really all the crucial expertise needed for governments in these very trying times. And Madam Minister, it is my pleasure to have you here today with us, and I'm happy to cede the floor to you for your remarks. Thank you very much.
So, thank you very much for this kind introduction. Dear panelists, dear participants, I'm grateful to the Wilson Center for hosting this event together with Liechtenstein, and it is a great pleasure for me to be here today. The Wilson Center is known for its non-partisan and high-quality expertise on pressing national and international policy questions. Our aim for today is to continue that tradition and to have an open-minded expert discussion on the future of sanctions in the context of Ukraine. The unprecedented nature of Russia's violation of international law, its brutal and blatantly illegal aggression against Ukraine, has triggered an unprecedented response by the international community. We have seen the adoption of comprehensive sanctions by the US and Europe on those who share responsibility for or are benefiting from that act of war. Billions of dollars have been frozen as a result. Liechtenstein has frozen $200 million in assets. The coordination across the Atlantic to detect sanctioned assets has been intense and quite successful, with the United States taking on a leadership role. The daily outrage we feel at the atrocity crimes committed by Russian soldiers and the immense deliberate destruction of civilian infrastructure make one thing perfectly clear. There must not only be accountability for these crimes, there must be redress. Those responsible for the destruction must contribute to rebuilding the country. This brings us right to today's topic. The step from freezing sanctioned assets to their confiscation and eventual repurposing. What legal questions does this raise and what challenges lie ahead on that road? There is an intense discussion on both sides of the Atlantic on this matter, reflecting its complex legal nature. As proponents of the rule of law, we agree that the confiscation of assets needs a strong and robust legal basis and the guarantee of due process rights. While some may see this as restraining our efforts, I believe that therein must lie our strength. After all, we are faced with a system of kleptocracy of high sophistication and criminal energy. To that, we must respond with an unwavering commitment to the rule of law and with the full force of the law, including its safeguards. In our view, there need to be two dimensions to our response. First, we have to further boost international cooperation and close the impunity gap. Significant parts of the assets that are frozen today under Russia-related sanctions may already be connected to violations of the law, including relevant anti-money laundering provisions. We have to look into ways to further facilitate investigations into complex international networks designed to hide the origin of stolen assets, in particular in cases where a government appears to be complicit. I'm optimistic in this respect, as we currently witness levels of cooperation of an entirely new quality to jointly fight kleptocracy and corruption. Second, we have to discuss with an open mind about possible improvements to our legal basis and what they could look like. In Europe, there is an interesting discussion about more consistently criminalizing the act of evading sanctions. that could also entail a stronger link between sanctions evasion and money laundering by making it a predicate offense. In my talks here in DC, I heard similar ideas, and I look forward to listening to the views of the panelists on this and other proposals. I also believe there is a useful discussion to be held on due process rights in connection with confiscations and the legal challenges that may come up in this respect. This is without a doubt an issue that needs to be addressed with the appropriate diligence. Finally, there is also the question of the frozen assets of the Russian Central Bank, which raises yet a different set of legal considerations with regard to confiscation. So far, no one seems to have found the silver bullet, but there is a full and rich menu of topics for discussion. But before we get down to the technical details, let me end on a general point. I truly believe that the open exchange of views, in particular on such matters of great complexity, will be a key strength in our response to the Russian aggression and in our support to Ukraine. Towards the end of my visit here to the United States, I'm confident that the cooperation between Europe and the US will continue to deepen and that we will live up to the task. I hope we can make a contribution to that end with today's meeting. Once again, I would like to thank the Wilson Center for hosting this event with us. Thank you.
Thank you very much, Madam Minister, for your informative and compelling remarks. Armed with this context and the information that Minister Marok-Wachter just presented, we now move into the panel discussion portion of our event. I'll introduce our three panelists, and then they will make their presentations, roughly 3 to 4 minutes each, starting with Mr. Andrew Adams. After our guests have made their presentations, we will open the floor for questions from the audience here present. And so now to introduce our distinguished panelists, Mr. Andrew Adams from our Department of Justice is the director of the Klepto Capture Task Force and will be able to provide us with an administration perspective. In March, Mr. Adams was asked to lead the DOJ's sanctions response to the Russian invasion of Ukraine, building on his experience in helping to stand up the U.S. Attorney General's Money Laundering and Transnational Criminal Enterprises Unit. Mr. Aaron Jordan, Deputy Chief Counsel, House Foreign Affairs Committee, will give us a sense of how Congress views this issue. In his role, Mr. Jordan oversees sanctions policy and international financial issues for the committee's chairman. And Dr. Robert Vollner is the Prosecutor General of the Principality of Liechtenstein and will provide more details on Liechtenstein's views. Serving as Prosecutor General for over 20 years, Dr. Vollner has made asset seizure and forfeiture priorities of his office's work and helped Liechtenstein to become a respected and reliable partner in the international fight against crime. So, Mr. Adams, if we could start with you first.
Thank you, Michael, and thank you to the Wilson Center for the invitation. Thank you, Madam Minister and Mr. Ambassador. Madam Minister, in particular, your remarks are extremely well taken. It's hard to overstate the degree to which I agree with every point that you made with respect to the importance of this process and the importance of due process in pursuing our aims. I am the director of the Department of Justice's Russian Sanctions Task Force. And what I'd like to do in the brief opening remarks is, one, just provide some context for what that task force is and what we're focused on doing. And then I'd like to make a quick point about one of the crucial tools in our toolbox, and a quick point about the importance of our international cooperation and international efforts in our overall drive. So the task force is a group of prosecutors, a group of investigators and agents that is housed in the Office of the Deputy Attorney General, so it's at the highest levels of the Department of Justice. The idea behind placing the task force there is to be able to draw on any number of expertise within the department. So we have people from our National Security Division, from our Criminal Division, from our Tax Division, without regard to a siloing of those powers and of that kind of expertise, but to be able to draw on the expertise from across the department. We have FBI agents, Homeland Security agents, law enforcement agents, and people in the intelligence community also assigned to the task force to support its efforts. And again, the idea there is to avoid any sort of siloing of abilities, siloings of power, but to be able to draw on all of the powers of the U.S. government for this effort. The focus and what we're trying to accomplish is really to give as much teeth to the U.S. and our foreign partners' sanctions programs as possible. The idea here is to plug holes in a system that our Treasury Department, our State Department, our Commerce Department, and our foreign counterparts are building together. And to that end, we have two broad focuses. The first is on people and entities who are on our OFAC SDN list, our sanctioned list of designated people. With regard to those people and those entities, the task force role is to bring any possible criminal action and any possible civil forfeiture action, irrespective of whether that is in the sanctions violation lane or money laundering. If we see an opportunity to bring visa fraud charges, narcotics charges, whatever it might be, the task force is here to bring that to bear. Separate from that is a broader and I think a longer-term project, and that is a focus squarely on sanctions evasion and on money laundering tied to it. But broader in the sense that we're not focused solely on people who are on the sanctions list. Here we're talking about facilitators. And so we're looking at financial institutions, both novel financial institutions in the cryptocurrency space and traditional banks, insurance companies, maritime and aviation services companies, et cetera. The idea being to go after people who are providing a professional service in the form of money laundering on behalf of the sanctioned oligarchs. That's the task force in a nutshell. And now, very briefly, I'd just like to emphasize the civil asset forfeiture tool. That is really at the heart, I think, of the discussion today. And the point that I would like to emphasize is one that I think echoes a point that the minister was making a moment ago, and is often something that is, I think, misunderstood or underappreciated outside of the federal prosecutors set here in the U.S., and that is the degree of due process that goes into our civil asset forfeiture program. It is not the case in the United States that merely being designated as a sanctioned oligarch means that property can be fully, finally, and forever forfeited to the United States. It is a process, and it's a long process in some cases, that requires a showing of a nexus to criminality, a showing of a nexus that particular property is the proceeds of a crime or involved in money laundering or is somehow connected to an existing crime. And it involves the ability of third parties and indeed oligarchs themselves to come to court and challenge us on those points, to have an opportunity to put the government to its burden of proof, and for innocent parties to come forward and say, I may own problematic property, but I am an innocent owner. I'm a bona fide purchaser, for example. All of that is part of any forfeiture proceeding in the United States. And I think it's important that it remain the case. The point that the minister made of distinguishing ourselves from authoritarian regimes by that commitment to due process, I fully agree, is an indication of strength. It is not a restriction in any meaningful sense. And the last point that I'll make in these brief remarks, and then I'll shut up, is the international component here. We have had, at this point over the course of the last 10 months, indictments, seizures of massive assets. We have had civil forfeiture cases filed. We've had searches conducted and interviews conducted here and abroad. There has not been a single action, there's not been a single enforcement action that did not rely substantially on international cooperation, on some degree of information, on some degree of assistance from an international partner. We cannot do this in the United States without that sort of international commitment. And the difference, I think, between now, today, and a year ago is the alignment of laws in the European Union, the member states of the European Union, European countries generally, the UK, and then in countries that are far flung from, I think, what we typically consider to be our core money laundering allies, to align international sanctions and to align our powers. What that gives us, as Dr. Vollner will certainly be familiar, is the ability to act in each other's jurisdictions through cooperation and recognize each other's powers. Having that sea change in place now makes this an effort that is truly multilateral, and I think we've seen the fruits of that multilateralism, and I think we'll only continue to see that grow. Thank you.
Thank you very much, Mr. Adams. And now, if I may, I'd like to turn the floor over to Aaron Jordan, Mr. Aaron Jordan from the House Foreign Affairs Committee.
Thank you, Michael, and I'll add a similar caveat that I'm speaking only for myself. I was asked to provide a congressional perspective for this panel, and indeed I will take that route given that I have nowhere near the same prosecutorial or legal expertise as my fellow panelists. In the immediate aftermath of Russia's invasion of Ukraine, members of Congress were thinking about what they could do and creative ways to use sanctions and export controls to respond. The administration came out, of course, with the Klepto Capture Task Force in the first week of March, and probably the largest avalanche of sanctions bills that I've had to review in my position came out that week as well. Most notably for our purposes here was Representative Tom Malinowski's bill, the Asset Seizure for Ukraine Reconstruction Act. The bill basically did what the title suggested. It subjected Russian oligarch assets within the jurisdiction of the United States to seizure and repurposing for Ukraine aid, security assistance, reconstruction. As the chairman of the Committee of Jurisdiction, my boss, Congressman Greg Meeks, Chairman Meeks, had to make a decision as to whether we should move the legislation in the markup. Our markup was strictly focused on Russia-Ukraine in the wake of the invasion in February 24th. And after extensive conversations weighing the costs and benefits, we did elect to move that bill through markup. Then, the night before the markup was slated to kick off, the American Civil Liberties Union, ACLU, came out against the bill. And they expressed significant concerns about lack of due process, about lack of there were significant concerns on their part as to the constitutionality of the bill. We knew that there was going to be concerns along these lines, but obviously that has an impact. And this is all public reporting. So the morning of the markup, we had additional conversations, and there was questions as to whether we should continue moving the bill, whether we should pull the bill, and ultimately what Chairman Meeks decided is to do a version of the bill that basically instructed the administration to come up with legal proposals for legislation that would give Congress a roadmap to have Russian, like ill-begotten Russian oligarch assets used for aid for Ukraine. And basically under the current version of the law, the administration had to create an interagency task force and report to Congress on these legislative proposals. So, and then they were also reporting on additional sanctions and so forth. So that was the compromise version that moved out of the committee in a bipartisan way. The chairman immediately took the bill to the floor with the strong support of House leadership, and it passed on the floor 417 to 8. Most notably, though, the administration, and obviously they have been looking at this closely beforehand, but the day of the bill passed, the administration came forward with the legislative proposals that morning, so they had already sort of acted upon the purpose of the bill. Without actually becoming law, the bill served its function. And as an aside, Congressman Malinowski took the ACLU's criticism of the bill as graciously as I've ever seen any congressman take any criticism of their bill. And his wisdom and intelligence will be missed from the committee next Congress. So upon extended dialogue with the administration after the legislative proposals came forward, the House settled on language that stated in key part, the Attorney General may transfer to the Secretary of State the proceeds of any covered forfeited property for use by the Secretary of State to provide assistance to Ukraine to remediate the harms of Russian aggression towards Ukraine. Any such transfer shall be considered foreign assistance under the Foreign Assistance Act of 1961. So that language was included in the House NDAA, which passed this summer, and there was strong support for it. That said, today, the conferenced version of the NDA will pass the House and then will pass the Senate. It's my understanding, knock on wood. And this language is not in the final text. It did not survive the conference process. So for now, this key language has not been passed into law. That said, I do not believe this is over. Strong supporters of Ukraine obviously really believe in this language and are going to continue to push for it. And additionally and importantly, I think the provision has appealed to more fiscally conservative types, precisely because instead of money coming from US taxpayers, it would come from Russian oligarchs and tycoons. So while there are real trade-offs, some of which we've talked about, to property protections, due process, and like the investment climate here in the United States, I would expect that members of both sides of the aisle are going to continue to push for careful, thoughtful ways to transfer ill-begotten assets from Russian oligarchs to Ukraine. Thank you.
Thank you very much, Mr. Jordan. And now we'll go over to you, Dr. Vollner.
Thank you for the... Okay. The war in the Ukraine is really close to us, and for our American colleagues, maybe just to give you a perspective, for us it's as if bombs were falling on Boston. That's how close the war is to Central Europe. And we feel the toll. We have refugees in the country. The citizens are feeling the consequences of the war in energy prices and in other fields. So the topic is very relevant to us. And we're following, of course, very closely what the EU is doing. I don't know if you all followed Ursula von der Leyen's statement last week. It was a surprise, the bluntness and the directness of the language she used. She said that she estimates the damages caused in the Ukraine so far at 600 billion, and that 300 billion of central bank assets had been frozen worldwide, 19 billion oligarchs' money. She used the term oligarchs' money and not designated persons and entities' money, which I think would have been more appropriate. But interesting was the suggestion to use the money while it's frozen, to put it into a structure to invest these funds while they are frozen and use the proceeds of the investment until you reach a forfeiture at the end. She also said that after the sanctions are going to be lifted, the funds should be used, those are the exact words, for compensation. And how this is achieved legally should be through an international agreement. Very interesting. I haven't heard more detail on it, how this should be obtained. Very interesting to hear the American proposals. Now, with the EU, usually when you go into the details, then you see the language is somewhat different. The Commission proposed a council decision. This proposal was adopted last week or 2 weeks ago on the 28th of November. And this is very important because it will make sanctions violations an EU crime under Article 83, Para 1 of the Treaty of Functioning of the EU. Now, while this doesn't lead automatically to forfeiture, it will, for instance, enhance mutual legal assistance cooperation, because you won't have the problem of dual criminality. And in all of the EU countries, sanction violations will be a crime and will be a predicate offense to money laundering. Now, this is very well and important, but the whole of this directive does not have any language included in forfeiture, any extended powers in that field, but there are plans to extend the directive on asset recovery and confiscation. That still has to be seen what's in there. Now, in the daily life of prosecutors, I think in those things you're discussing, there are two topics quite different. The one is the central bank money, and the other one is designated persons and entities money. With the central bank money, which would be a sweep of 300 billion at once, international lawyers tell me that there are issues of immunity and sovereignty. Treasury experts are discussing whether this is really a good idea to go after that money, what the consequences would be for the stability of the financial systems. And those questions, I think, need to be weighed. There is precedent of the US taking Afghanistan's central bank money, which was a step taken, but this would certainly be on another level. As a prosecutor in the field, I would be happy if this would be possible. It would take some pressure off the cases that we have, because in our real world, in our cases, it's really hard work. I was at OIA yesterday, and Mary Butler, who's the chief of the money laundering asset recovery forfeiture unit, she said each and every forfeiture case is hard prosecutors and investigators' work. And this is certainly the case with these designated persons and entities. The experts at the EU on Eurojust level, they've been exchanging on potential cases. I was surprised that the estimation was very defensive. They were talking about 15 to 20 cases that could possibly build. And in all the other cases where you cannot have a criminal forfeiture, you have to think of other ways to go. And a good way is what you call in the US civil forfeiture, a term we don't like because it causes confusion in Europe. It's better to call it non-conviction-based forfeiture, because civil makes people think in civil law countries that this is a civil action and it has nothing to do with the state. Well, in fact, it's the state going after the assets. It caused such confusion that we had to amend our mutual legal assistance treaty with the US to include cooperation in civil forfeiture cases. I think this is a really good road to explore, because you mentioned the burden of proof can be different, and it can be easier to obtain. International cooperation, of course, is essential. But how do you get all the other assets of designated people where maybe even with the best international cooperation you cannot make a link to criminal activity or money laundering? What should happen with those assets? Well, of course, one could have a radical idea and say countries could think about confiscation laws to actually disappropriate people by law, which was done, for instance, in the Beneš decrees after the Second World War to people holding German nationality in the Czech Republic. This, of course, would raise immense constitutional questions, and all of our constitutions have the guarantee of private property And I think we all agree that you cannot just go and pass a law in Parliament that private property is confiscated. Well, there is people arguing and saying the Russian aggression is such a blatant disregard of international law, so it's a defensive measure, so to speak, and it's kind of a countermeasure, an international law countermeasure that allows you to undertake such a drastic measure. I will leave it at that. As a lawyer, I will just say under our constitution, I don't think our parliament would consider a law like that. I think in most European countries it would be the same. Another thing that would maybe be interesting to look at is the Italian anti-mafia laws, which have some very clever procedural provisions which can be very helpful in civil forfeiture proceedings. So as our minister said, nobody has found, how did you say it, the silver bullet. I think it's a good time to think about those things. And for the time being, prosecutors must cooperate closely. And sometimes cases where you think there is no case suddenly do develop into good cases. Thank you.
Thank you very much, Dr. Vollner, for those remarks. And so now we're into the moment of Q&A for our distinguished panelists. As your humble moderator, I'm going to kick off with a question that I imagine is on our minds and try and ask each of you to answer it if you could, and then we'll take questions from the floor. So I was actively listening and taking notes, and I guess for me, I'm not a lawyer, so I'm thinking in sort of broad conceptual terms, but it strikes me that that maybe nations are already doing this on a certain level. Different nations are doing this already concerning their own citizens on certain levels, but now we're in an international, sort of base of operations here, and so I'm wondering what is the entity that we would be using? Do we have to create a new entity to move forward in this area? If all the countries that needed to be in agreement were in agreement that yes, we want to do this and we want to change our laws to move forward, does some sort of new body, international organization or body need to be created, or do you think we can proceed forward with this kind of new legal framework and authorities using existing structures?
Well, thank you. I think from our perspective, if DOJ, the focus has obviously been on utilizing U.S. tools, and the number of oligarch assets, central bank assets, were there to ever be on the table in the United States is relatively low compared to what exists in the rest of the world. That said, I think our focus in terms of new structures has really been on what may be needed for restoration of funds to Ukraine and what that entity, essentially a bank or a bank account, may look like at the end of the day. For pursuing the assets itself, that hasn't been a focus within the U.S. in terms of teaming up with some multilateral task force that is more sort of formally instituted. What we do have, though, in addition to the task force that I direct, is a task force within DOJ and Treasury called the REPO task force. That's the Russian elites, proxies, and oligarchs task force. And the notion there is one largely of coordination and sharing some learnings and sharing information about the tools available and locations of particular targets and assets, things of that nature. And it's been a fantastic forum that goes really beyond our normal or sort of most frequent partners, but it expands the G7 and Australia at this point. And that has really, I think, from my perspective, been the body that is set up and is driving multilateral conversations forward.
Well, as long as you're drawing from existing resources and put the experts together, and if you call it a task force, that's very well with me. I'm always a bit skeptical to build up new international bodies for this kind of work. And when President von der Leyen talked about a new structure to invest the funds, that's maybe a separate issue where this is relevant. But for the following up of cases, I'm skeptical that we need this. What we need is that prosecutors and investigators have enough resources and do their job and go after the cases and coordinate in this format that you have in the US or in the Freeze and Seize task force within the EU and the G7. I don't think we need a new body for that.
I would mostly agree with my fellow panelists. The title, I think, is From Freeze to Seize, the Future of Sanctions. I think the general sentiment is that seizing is probably less likely to be the future of sanctions, and this is an extraordinary case, which would make it which would provide less purpose for sort of a new international structure, which is why the focus, I think correctly, has been on coordination and working together and diplomacy as opposed to creating a new international forum.
Thank you very much, Mr. Jordan. So we'll open the floor up to people with questions, and if I could just ask, make sure you press your button when you're using the mic and then turn it off when you're done, and also identify who you are and where you're from. Yusuf.
Thank you very much. Especially to the Wilson Center and also our colleagues from the Liechtenstein Embassy for hosting this very relevant event on this topic. And thank you, Minister Marok-Wachter, for your inspiring remarks. My question is maybe to Mr. Adams and Mr. Jordan. I heard your testimonials with great interest, Mr. Adams, at the Senate Banking and also, I think, Foreign Relations Committee on what the Klepto Capture Task Force proposal for legislation would be, especially extending RICO, IEPA, have that sanction evasion crimes included there, extend the statutes of limitation, extend international cooperation. And maybe my question to Mr. Jordan, of those measures proposed by the Biden administration, how much at this stage has been taken up by Congress in its legislative proposals? There was a lot of back and forth. The current version of the NDAA is over 4,000 pages. I lost a bit track on what's in there and what not. And yeah, thank you.
Well, I think to the extent that the question is about what's in or out, I'll certainly defer to my friend from the Hill. But you're correct in terms of what the administration and the department's proposals had been, and the focus had largely been on expanding, one, our abilities to pursue ultimately forfeiture and criminal actions through, as you say, the expansion of racketeering enterprise definitions, extension of statute of limitations so that we can investigate what are often extremely opaque networks that do indeed take years to dismantle. But critically, it included the expansion of power to transfer assets at the end of the day. Whatever slice of seized and ultimately forfeited assets may fall into that bucket has obviously been a key point of conversation on the Hill, but I'll defer on that. But I think the drive here has been, as I say, one, to shore up the sanctions regime just generally, but two, to ensure that what we forfeit through this effort is made available for Ukrainian reconstruction as small a slice of what is needed as it may be.
So the main provision that the House had pushed for and had strong support of the relevant chairman, and part of the difficulty just in general with very complex legislation is a lot of times they cross through multiple committees, jurisdictions, so judiciary, financial services, foreign affairs on the House side, banking, foreign relations, and judiciary on the Senate side. So everyone gets a bite at the apple, both sides of the aisle. So there's a lot of voices in the room. Part of the conversation on some of the proposals was scope, whether it goes beyond this Russia-Ukraine context, like a sunset, whether when or if there would be a sunset. So all of those kinds of, it's not clear. IEPA is already a statute that gives the president and immense power over sanctions. For our, like, Chairman Meeks' perspective, I don't think he has concern with how President Biden would use any additional authorities. But regardless, if we're going to change IEPA to add even more discretion, that's certainly a conversation that's going to pique people's interest. So those types of questions all played into conversations. And like I said, I think it's an ongoing conversation, and things will continue to be discussed.
Yeah, hi, thank you very much. My name is Greta Fenner. I'm the Managing Director of the Basel Institute on Governance and the International Center for Asset Recovery, which coincidentally is also funded by Liechtenstein. Thank you very much, and Switzerland, for full transparency. I'm really grateful for this conversation because early on, as many of you, we were very concerned about the relatively unqualified, bold, probably populist statements about how this money is going to go and fix Ukraine. So I'm incredibly grateful for having a substantial and intelligent conversation to start with. And we've analyzed something like 40 jurisdictions across Northern America and Europe, and we come to exactly the same conclusion. There is certainly no golden bullet. I would like to really stress what you said regarding non-conviction-based forfeiture, and I think this is where, if we can use this horrific tragedy in Ukraine to move something forward that will help us beyond Ukraine, it is that we need more global implementation of that legislation. I'm curious to hear from you, Adam, because in Europe, the large majority of countries do not know this, and if they do, which is my own country, Switzerland, it doesn't quite work because they still expect criminal standards for giving mutual legal assistance, for example. And we see that as a huge problem because Latin America, Sub-Saharan Africa, Northern America, you are leading on this, and Europe is really lagging behind. So perhaps this is more of a comment, and then I have a quick question. I really see this as a moment for at least pushing the world forward and implementing more systematically this kind of legislation because it's hurting a lot of countries and not only Ukraine. The question I would have when we talk about another thing that could hopefully emerge out of this for the benefit of longer term fighting financial crime is in relation to international information and intelligence sharing. And I'd be quite interested in hearing from the practitioners on the table whether you have identified or even started using mechanisms specifically to this situation, which were perhaps created or facilitated by this crisis, that could be further explored and maybe standardized going forward, because we do know all the hurdles of mutual legal assistance and so on and so forth, which I don't need to explain. So I'd be curious to hear your view on that. Thank you.
Thank you. Certainly I think the comment and the question go perfectly hand in hand. To respond, I think, to the comment, and to draw back to something that Dr. Vollner mentioned, which is the Italian anti-mafia law, there are opportunities around the world to be creative in how we phrase requests and how we frame our requests. So it's true that if I walk into country A in Europe and say I want an arrest or I want a seizure, and the only basis is a sanctions violation, then more often than not I'll be told there's no dual criminality. But of course, in taking a holistic approach to a lot of these cases and trying to tackle these problems almost as organized crime cases, we often have the ability to describe this, one, as organized crime, or as bank fraud or as wire fraud, or something that has some resonance abroad. And on the organized crime part in particular, you see through the implementation of the UN Convention on Organized Crime, transnational crime, to some degree, the UN Conventions on Terrorism, you do see some ability in pockets of the world which have broadly implemented those UN treaties, some ability to take some action. And in this instance in particular, in response to this crisis, I think you see a lot of creativity on both sides of the table to make these situations work where we can. In terms of essentially what may be on the table going forward, I certainly get the sense that there is a strong drive in the EU and in certain member states to expand these powers to speak to civil asset forfeiture or non-conviction-based forfeiture in particular. But even if the status quo were to hold today, I think that there is plenty of room to operate for prosecutors who are willing to get creative.
If I may, Greta, thank you for the good remark and question. Well, making sanction violations an EU crime will help here. It's amazing to me that still in Europe there are member countries where this is not a crime. In Liechtenstein, certainly it is a crime, and it is a predicate offense to money laundering. At least the serious sanctions violations is. This will help, and I think that otherwise the measures are in place, certainly within Europe. They just need to be used, and what's being done now at Europol and Eurojust, the coordination taking place in those cases, including third countries, is very good. And it's at those meetings that you have ideas like you just mentioned. You look at the case and you see, oh, maybe we can go beyond the actual sanctions question. There is another threat to pick up, organized crime or other roads. So I think those information exchange channels do exist. They just need to be used. Like on the FIU level, there is such well-established information exchange channels now through the Egmont group, and they get used. It's just amazing sometimes in real cases that this hot information sits somewhere, but if it's just sent out without a contact, it just sits there and nobody does anything about it. So sometimes the problem is really not that it's not being exchanged, it's that there is someone on the other side who doesn't pick it up. As far as oligarchs are concerned, I think what we will be seeing more and more now is that there will be areas in the world where they can still act without much risk, whether they are in Africa or in parts of Asia, and that certainly will be an issue, in my opinion, in the future.
I think this will be our last question. So
Hi, I'm Michael Burke from the U.S. Department of Justice, Money Laundering and Asset Recovery Section. I have an observation and a question. My observation is that it seems as though this trend toward criminalizing willful avoidance of sanctions is going to be a game changer. And at least, but as Greta's pointed out, we still have the problem of, you have the two parts to the mutual assistance problem, getting the evidence to get to forfeiture, and then getting the other country to register and enforce your forfeiture judgment. And on the latter one, the lack of uniformity on non-conviction-based forfeiture is going to be a huge problem, although I think progress is being made there. Certainly, the FATF recommendations urge countries to, even if they don't themselves have non-conviction-based forfeiture, to recognize it in other countries. I'm seeing more and more of that. Luxembourg would be a good example of a country that, based on case law, has recently recognized that. So there's progress there. But part of their observation is that you're really going to have to craft these cases, and at this charging stage to the mutual legal assistance, that it's going to be sought from particular countries. A lot of countries don't recognize RICO, our racketeering statute. There are all kinds of, practical impediments. So that's the observation. My question is, I'm very intrigued by this legislative proposal, but the one thing that wasn't clear, there currently are two ways to get money out of our asset forfeitures funds. First of all, in the United States, all forfeitures, with very exceptions not relevant here, all that money has to be deposited into an asset forfeiture fund. There are two ways to get it out for purposes other than expenses related to the program. One is based on asset sharing, which is premised on cooperation by countries, which we're not going to get from Russia, very likely. Although we may with others. And the other is victim remission, which is an administrative program where we recognize pretty narrowly defined direct pecuniary losses. So the part I missed is are there provisions for, if we can get to the confiscation with these new laws, then does the legislation address directing the money either into the fund and then give authority to take it out for this purpose, for example, funding analogous to Foreign Assistance Act funding, or does it directly segregate that money at the time of forfeiture based on predicate offenses or something like that? Because that's a mechanical point that makes it critical to get the money out and return it. So that's my question.
Great. And it's a mechanical point where having the expertise from folks at MLARS has been critical throughout. It's a bit of a moving target is sort of the answer. Fundamentally, you're absolutely right. There are limitations on what we can do, and often when we're talking about a sanctions violation event, the victim, to the extent that there is a victim, is OFAC or the United States writ large, and not a particular person who's going to come in and put in a remission request. And that's a limitation that we're facing here. If what we want to do, as we want to do, is to direct funds to Ukraine ultimately. So the legislative fixes have been focused on that issue and on that problem. As a mechanical point right now, what we have are funds that are sitting in the seized asset fund rather than the asset forfeiture fund, and they're likely to sit there until we have a fix.
Thank you very much for these questions and the excellent answers. I know I've learned a lot, and I'm sure everybody at this table has as well. We've reached the time where we need to draw this to a close, so I would like to thank Minister Marok-Wachter and Ambassador Sparber for your remarks and our panelists for this very enlightening discussion today. I also want to thank the Embassy of the Principality of Liechtenstein for their continued collaboration with us on this and other issues of global import. Liechtenstein is an advocate for democratic governance and diplomatic engagement and promoting the rule of law in Europe, and will be assuming chairmanship of the Council of Europe in 2023. We enjoy partnering with Liechtenstein, a valued friend and partner, on promoting security, justice, human rights, and other shared values, and on strengthening multilateralism in the UN and other organizations, and on combating financial crimes. We appreciate Liechtenstein's efforts to hold Russia to account for its brutal war against Ukraine, including through its strict enforcement of sanctions. Our thanks to our AV team here at the Wilson Center and all the rest of the Wilson Center team for pulling this together. And thanks to the members of our audience, both online and here present in the room, for their excellent questions and for helping the Wilson Center to perform its mission. Thank you very much.